Good morning. How are you guys? Slept well? Yeah, great. Online friends, good morning. They'll still be sleeping. Let's see. Online guys, can you hear me? Okay, so yesterday we did the basics. I mean, in the sense, the small introduction. Today we will, yeah, you can hear, right? Okay, good morning. Okay, guys, so today we will move on and actually start the classes and the concepts and all that. So you have the material, page number 34. So did you get to download the Bear Act? Yeah, okay, great. We can use that as well. So I have this subscription by Taxman, so it's fine. All right. So glad you can hear me, guys. So let's go ahead. So first of all, very good morning all. Hi. Yes. Okay. So if you see, guys, this is the Bear Act. Even you can check in your phones as well. So generally, how does it look? I mean, there are many, as you can see, there are many chapters. Can we see that? There are many chapters. How many chapters are there? How many chapters will be there? Any idea? How many chapters? 20? How many? 24. How many chapters? 29. Yes. So Companies Act has 29 chapters. And if you see here, I mean, few chapters, I mean, this is chapter number 1, like that. Yeah. Good morning, Shrira, Maitreya, Vivek, hi, and others as well. I've been seeing. So if you see, there are 29 chapters, and each chapter depicts something. For example, chapter number 10 talks about auditors, right? Chapter number 9 talks about accounts and audit. Chapter 7 talks about management and administration. So few sections. For example, in chapter number 10, it starts with which section? Any idea? 139, correct, to 148. That's how it is. Then if you see chapter number 9, that is accounts, it starts from 128 to 138. It's like that, right? So that's how it works. Accounts, it doesn't mean only 10 section makes one chapter. Few chapters are more, few chapters are less. It's like that. So predominantly when we are doing our particular concepts, so if you see in IPCC, you had till almost around 138. All this you had 147 till 148 you had, honestly speaking. So from CA final onwards, does it mean that the old sections won't come? No. New sections include, new syllabus includes the old one as well. So stuff from this also can definitely be asked. And anyway, in your auditing, it starts from your auditor's points anyway. That is from 139 onwards. So this anyway is there in your auditing, you know, in your auditing subject. Nevertheless, for CA final, predominantly, though it appears to start from this, but it is nothing like that. Though it appears to start from chapter 11, because from chapter 1 to chapter 10, you would have studied in inter. But there are a lot of interconnections, and that also they will ask. So it is not that only chapter 11 onwards we have. We have the full set of 470 odd sections for our examination, and stuff has been asked from previous thing also. So that's the thing. So chapter 11 onwards speaks about what? Appointment and qualification of directors. Before we even move into all these things, before we get into all these things, all these who can be a director, who cannot be a director, and all those things, this question I want to ask you, which is there in page number 35. So you tell me the answer. Before we go into any of those things, who is a director, who is this, all that, will come to that. We have not even started. So see, I told you we have connected two sections, all that we will see. So one disclaimer I want to give you for the next 2-3 days, you will be wondering what the hell is happening. I'm telling you now only. Next 2-3 days, you'll be like, what is this happening? What? It's like some interstellar movie. You watch Christopher Nolan's movie? It's like that. So you'll be like, what is happening? I don't know what is happening. Why did I come to class? All those feelings will come. So my only request is control the feelings. 3 days, 2 to 3 days. After that, you will only understand what I am connecting where. So first 2-3 days, people will actually feel it. Many people have told me. So first 2-3 days, I was like, why did I join the class? What is happening? I don't understand what is happening. Because what we are doing is unlearning what you have learned in inter and learning, afresh. When you are learning afresh, you are coming out of your comfort zone. In inter, you would have studied some textbook. Bare Act and all did you study in inter? No. Even honestly, when I didn't know what a Bare Act was. So the thing is, it's fine. So we are unlearning what we did and learning again. So do not worry. Online buddies, is it okay? 2-3 days you'll be like, why I might as well sleep. Correct? Don't sleep. The thing is, what we are doing now is something which is something out of your comfort zone. So please bear with me. Again, I'm giving a disclaimer. 2-3 days, you will not know what is happening. You don't need to know also. You just need to understand the concept. Concept you'll understand. But what I'm saying is, I'll be seeing so many sections. You'll be like, so confusing. I might as well have studied from the textbook rather than coming to class. All those feelings will come. It should come actually. Only then you're going in the right way. All right, guys. So let's start. So first question is this one. Page number 35. Page number 35. My Ahmedabad friend, Mr. Patel, I hope you got your the PDF or till page number 40. Yes. So if you see this question, who is more powerful? What do you think? Shareholders or board of directors? Shareholders. How? Shareholders have the power to remove board of directors. Okay. Can board of directors remove shareholders? No. Can anyone remove shareholders? You can buy back the shares. Then forfeiture is there. Those are some of the things. But can board of directors? Okay. Just because shareholders can remove board, is board more powerful? Or is shareholders more powerful? Just because I can remove board of directors, would shareholders be more powerful? What do you think? First, he's saying for certain approvals, so by the benefit of my online friends also, for certain approvals you need to take the approval of whom? Shareholders. Okay. Otherwise, board can do. How is it? Limited to the powers. Board has limited powers. Good. So this is how interaction should be. So basically, this is what the scene is. Who is more powerful, shareholders or the board? So if you want to have any confusion, you can scan. This is what we have done all this time. We have added some concept videos also. So if you have any doubt on this later, you can just scan this. It will take you to that video and you can watch that video. Anyway, coming back to this. Who is more powerful, shareholder or board? Okay, Parth, sorry, I don't know why they sent that. I'll ensure that you'll get the correct one today. Yeah. Hold on. Okay. So anyway, man, you can just make a note. You will get, I don't know why they sent you the wrong stuff. Sorry. Yeah. So who is more powerful, the shareholders or board of directors is the question. Some may feel shareholders, some may feel board. Because shareholders have the power to remove board, you may feel it's the shareholders. And let's see. So for this particular thing, we need to read one section, and that is section 179. I will be giving you a lot of section references. Do not get worried. You will get there. Trust me. Section 179. So it's there on the screen for you. It's easy. Or you can see your, phone as well. No problem. But whatever it is, let's read. The board of directors of a company. The board of directors of a company shall be So if you can see, I am just highlighting a few words. A company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. Shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. Now, first of all, it talks about the board of directors. Now, if I see who is a director, now if I link it, who is more powerful, director or board? One director or board of directors? Board of directors, okay. And this particular line, if you read, will this apply to private company, public company, or any company? Any company. Why? A company. Perfect. And when I use the word shall be, is it discretionary or is it mandatory? Mandatory. Shall. May is discretionary. Okay, you may do it, may not do it, it's your wish. Shall means mandatory, right? Generally. Entitled is a right or a duty? When I use the word entitled, is it a right or a duty? You are entitled to do it means right or duty? Entitled is always a right. Entitled is always a right. To exercise all such powers and to do all such, okay, we'll just stop here. First of all, board of directors of a company. Now, it says directors. Can director be a company, or rather can company be a director? Okay, can company be a shareholder? What I am asking is, can, for example, A Limited, B Limited, C Limited, can they start a company D Limited? Possible, 100%. So, A Limited, B Limited, C Limited are all shareholders. Can A Limited, B Limited, C Limited also be directors? Because on D Limited's board. Can D Limited's board of directors have A Limited, B Limited and C Limited as directors? What do you think? If yes, why? If no, why? Online friends, you need to reply. Yes. Director is always an individual. Where does it say so? Correct. Director is always an individual, 100%. Where does it say? It is in the definition of a director. Okay. So, cool. So, you say definition of director. See, always remember in the Bear Act, in Companies Act especially, the definitions are always given in section number 2. Correct? Definitions are always given in section number 2. So, basically, if I just read, if I write this section like this, for example, I am just randomly telling. Some random section I am giving. It is not even there in the Bear Act now. Actually, it was in the old law. Anyway, what will I call this section? What would I call this? Subsection. And this clause. Correct? And this clause. What is this? Subclause. This is how the usual sections are. Right? This is how the usual things are. But very interestingly, in section number 2, this is the definition section. So, definition has various, you may feel they are subsections, but for definitions, these things are called clauses. Only for definitions, these things are called clauses. So, it's called 2 clause 1, 2 clause 2, 2 clause 3, though it appears to be subsection. Right? You can, while reading you can tell like that, it's okay, but just I'm telling technically for definitions, it's called clauses. So, only for definitions. For definitions only, if I say 220, it is section 2, though it is not subsection, though all other sections it's subsection, here it is clause. Clause 20. So, all the definitions are given in alphabetical order in section number 2. So, we have to sit and search what? Director definition. Director. Here. Amazing definition. The person, when they are discussing, they'll be like, Macha, what is director? Director means what? Director is appointed on the board. But it has a very good definition. I'll tell you why. First of all, if you just observe these wordings here, means, includes, means, this is very, very important. Means, see again, means, what is the difference between means and includes? And if you see 234, means, dividend includes. So in every definition we need to see what these words mean. So what do you think? What do you mean by mean? What do you mean by mean? Tell me. So if you see, I have given it. Earlier I used to give it in other things. Here. Page number 34 only it's there. Page number 34. When the definition use the word means, it means it is exhaustive or restrictive. Means what? No other meaning can be given than whatever is already there. No other meaning can be given. So when I say director means a director here, director means a director appointed to the board, no other meaning can be given. Means what? If you have to be a director of the company, you have to be appointed to the board of a company. Means what? The appointment procedure has to happen. If the appointment procedure does not happen, then you are not a director. For example, in a company called INC Limited, there is a director by name Manmohan. This has got nothing to do with any other politician or any other thing. INC also doesn't mean anything, right? In a company called INC Limited, there is a person called Manmohan. Manmohan is like a dummy director, right? This has got nothing to do with any live incident, right? So Manmohan is a dummy director. So Manmohan is being controlled by some other company's director called Sonia. Again, this has got nothing to do with anything, right? So Sonia controls Manmohan. Manmohan is just a dummy director, puppet. So all actions of Manmohan are being controlled by Sonia. Is Sonia a director of INC Limited? Is Sonia a director of INC Limited? What do you think? Yes or no? Is she? No. Why no? Yes. Is Sonia appointed on the board of directors? No. Sonia is not appointed at all in the board of directors of this company. Since Sonia is not appointed in the board of directors of this company, show you an interesting thing. I'll just show you the 1956 Act. Again, I gave you a disclaimer. First couple of days you will be like, what the hell is happening? Why did I come to class? I could have just studied somewhere else. Because you are unlearning. We never studied Bare Act in CA in our old stuff. We never did it. So now let's do it. I'm just opening the 1956 law for you, just to see. It's always, if you see the history, no, you will understand the differences. What could have been the definition of director, what could have been. So like that, if you keep on seeing certain things, so you'll understand that what was the scene before, what is the scene now, like that. Yeah. See, this is the old law, guys. 2 clause 13. Old law. Is there any change in the definition from that and this? Yes. Here it says director includes any person occupying the position of director by whatever name called. Means even though you are not appointed on the board, but if you are acting as a director even outside, then you are a director. So is Miss Sonia a director as per old Companies Act? Yes. Is Sonia director? Karthik, if the screen is blurry, just switch off, switch on, it will come. When I say switch off, switch on, just exit and come back. Yeah, so if the director includes any person, as I told you. Is Sonia the director now? I mean, of INC Limited under the old Companies Act? Yes. But here is she under the new Companies Act, 2 clause 34. So just to give an example, Sonia is definitely a director under the old Companies Act, 1956 Companies Act, 2 clause 13. But she is not a director where? In the new Companies Act, 2 clause 34. So this one, a person who acts as a director, though a person is not a director, who controls the show, is called as a shadow director. Is that person actually a director? No. It's called a shadow director. It appears that shadow director was recognized in 1956, but shadow director is not recognized in 2013. Correct? Shadow director is recognized in 1956, but shadow director is not recognized in 2013. Which means, is it a loophole? Is it a loophole? Can now, from outside, can I control companies and still not be called as director and not be responsible for anything? It appears so. It appears. Maybe there is actually something to plug the loophole, that we will see later. But is that a loophole? Yes. So if you see, by the way, earlier definition 2 clause 13, they say director includes a person, which means this said, I already know who a director is. Director is a person appointed on the board. But it also includes, over and above that, any person occupying the position of director. So when you already know the meaning of certain words, you will use the word includes. So if I say this classroom includes people who are writing in November also, which means what? Predominantly it has people writing in May, but it also has November people. But if I say this class means May students only, means exhaustive. No other meaning can be given. So that's the beauty of these things. If you see 2 clause 35, the next clause only, it says dividend includes any interim dividend. What is dividend? You already know. What is dividend? Return on shares, return on capital. That is dividend. Any return that you are getting on capital is called dividend. That anyway was not needed for any definition also. Right? Includes any interim dividend is what? Means even interim dividend is a part of dividend. Is the screen fine now, guys? Is the screen okay? Yes or no? If you want, I can stop streaming and start again. Is it okay now? Yes? Okay, great. So dividend includes any interim dividend. Are you getting the point? Here it is means. Here it is includes. So the conclusion now, what can we draw? In 2 clause 34, shadow director concept is not there. It appears to be a loophole where people can misuse the provisions of director. We will see whether it is the case or not. Done? Next. So is this understood? Let us your. Now if you see again 2 clause 34 means a director appointed to the board. It still does not answer my question. My question was, can a company be a director? Correct, no? Can a company be a director? Here nowhere it says individual. Though you know company cannot be a director. You know it. But the problem is when a client comes to you and says, sir, can company be a director? The layman will not know all these things, right? Can company be a director? What will you say? No, sir, company cannot be a director. Can you just tell me where it is so that I can substantiate my claim? That is your opinion, no? They'll come for your opinion. Sir, this one part don't ask. I had left it in choice in the exam. Can you tell like that? No. You'll open the textbook and see. No. That's why it is very important to read the Bare Act. Because tomorrow when a client is sitting in front of you, you cannot say, sir, I did not do this, sorry, I did not understand that, this one part I left in choice, all that we cannot tell. So it is very, very important for us to know what is the thing. 1 second. Is it fine now? I have switched off and switched on. Yes. So if you see, that's the thing. Dividend means director means a director appointed on the board. So it still does not answer my question. So that is the reason why if I keep searching elsewhere, I will get section 149, which is my chapter number 11. This is how we connect. In section 149, it says every company shall have a board of director consisting of individuals as directors, consisting of individuals as directors. So every company, whether it's a private company, public company, whatever type of company, shall mandatory have a board of directors. And what do those board of directors have? Consisting of individuals as directors. Who are directors? Who are appointed on the board of the company, appointed. So that's the thing. So if you see, both are given here only, guys, page number 34. Both are given here, page number 34. Online friends, all okay? So yes, so if you see, this means so what do you mean by means? It is an exhaustive definition. You have already seen that. No other meaning can be given when I use the word means. Then appointed means what? Shadow director is there or not there? Appointed means basically you should go through the provisions of law. So it should be appointed as per the provisions of law, provisions of Companies Act. So shadow director is not there. Shadow director. Shadow director is not a director as per 2013. But in 1956 is a director. Under which one? Which clause? 2 clause 13. Just for your knowledge, that's all. Online buddies, are you there? Did you get it, guys? Means exhaustive as per the provisions of the Act. Shadow director is not a director as per 2013. So in 1956, 2 clause 13 is there. Yes. Then we saw this one, no? Every company. Every company means what? All types of companies. Shall, mandatory in nature. Shall have a board of directors. So they are talking about a group of directors called board, consisting of individuals as directors. So through 149(1) we have understood that individuals, directors should be individuals, which you anyway knew. Now you know where it is, that's all. You anyway knew. We are not stupid. We will not tell company can be director. But I know, I just want to know where it is. So you felt that it was in the definition. It is actually not in the definition. It is in this. It's okay, but fine. That's how we need to see. All definitions are always in section 2 and various clauses. You can figure it out. So as discussed here, when there is means, it is exhaustive and restrictive in nature. For example, this one 2 clause 34. Includes will be 2 clause 35. Dividend. Dividend includes interim dividend. There are certain definition which speaks about exclusion also. Means they say these are the things which are whatever it is excluding the above. All combined actually, if you see the goods definition in Sale of Goods Act. Sale of Goods Act goods definition 2 clause 7. What does it say? Goods means all kind of movable property. Correct? You would have seen. But excludes two things. Actionable claim and money. Yes. So there you would have seen excludes. Goods means all kind of movable property. So actionable claim means actionable claim is nothing but your debtors balance, factoring. Debtors balance, will you sell it to some other company, bank? Yes, there is a concept called factoring which you studied in FM. So will you sell that, transfer that receivable to somebody else for money? Yes. Or even bill discounting, that is also the same thing. So where the bank will take over later. So it says goods means every kind of movable property. So even that is movable. Money is movable, but they specifically exclude money. That's why they use the word excludes. Then they also say, but includes also moving crops, grass, all those things which you have seen, stock, shares, all that. So that's the same. So if you see definition say means, it means what? Exhaustive definition. It is exhaustive or restrictive means. Includes an inclusive definition, excludes an exclusive definition. Example is goods. Goods means all kind of movable property, but excludes actionable claim and money. That is the same. So if you see 2 clause 34 and 149(1), every company shall have a director, board of director consisting of individuals. We actually were in 179, if you remember, and we wanted to understand who is a board of, what is a board of directors, and we also wanted to understand who is a director. That's why we came down here. We still have to go and answer that question which we are answering, which is that who is more powerful. Correct? This, since we are seeing so many sections, that is why you may get confused. That's why I am trying to tell, ignore the section number and all that, understand the concept. In the 2 days, I can assure you will understand all concepts. But if I ask you section number, you will be like, what did he say? I don't know, like that. So if you see that, you don't worry about it. You will eventually figure it out, right? So coming here, guys. So basically, we came to these two to, well, understanding this question in page number 35. In understanding page number 35, in trying to understand page number 35, we came to those two areas, because in page number 35, which is nothing but 179(1), what did we see? The board of directors of a company. So to understand this board of directors concept, we went there. So now we have understood already, so let's come back. So who is the board of directors? We have seen 149 and 234. Correct? So generally, instead of telling 2 clause 34, you can still say 234. Pause and say 34. It doesn't mean 234. It is 2 pause 34. So we have already seen 2 clause 34 and 149 and understood who is this board of directors. Basically, board of directors is a group of people, individuals, who have to be appointed as per the provisions of law. Every director has to be appointed. Shadow directors are not there. We still haven't fixed that loophole. What is that loophole? Shadow director can aram say do whatever he or she wants. No. Will shadow directors be liable? It appears that in the old act they were liable. It appears in the new act they are not liable. It appears, but it is not so. We will see that later. So the board of directors of a company. If you clearly observed here, for the word every, how did I interpret every to be? Each and every company. For the word a, what did I tell? For the word also, what did I tell? Each and every company. For the word all companies. So basically guys, there is a chapter for you in the CA final old syllabus, no? There was a chapter called Interpretation of Statutes. This has been now shifted to CA Inter New. You are the unfortunate set of people who did CA Inter old, correct, no? New only you did. Oh, super. So if you did CA Inter old and CA final new, you will miss this chapter. But those of you who have done CA Inter new, you have skipped this chapter in CA Inter, correct, no? Pakka. Anyway, 4 marks will come, we'll study this, leave it. This is the most important chapter for law, believe it or not. Correct? So, if you are old syllabus, you anyway would not have studied also. New syllabus, CA Inter, interpretation, something is there, something and all is there, leave it. Bouncer only, leave it. 100%. Because so stupidly they have given in the institute material also, something and all they have given rather than explaining what it is. So statute means what guys? Law. Interpretation of statute means what? How to interpret the law. Basically now, if you think about it, a chartered accountant interprets the law. Who is the law making authority? You know, legislature, right? Who executes everything? The executive. And who interprets the law? Judiciary, we know that, the judge. But before going to judge, before it becomes a court case, the clients will come to you for an opinion. And what would you do? Interpret. What could be the meaning of what could be the meaning of every, whatever it is. So interpretation of statute, we have accounting standards, standards on auditing, we have your ICDS and all that. This also is nothing but a standard of interpretation. Standard of interpretation to be followed by the judges of our country. But why are we studying? Because before going to judges, it will come to us, no? It is up to us to allow it to go to a judge or not by interpreting correctly. All your opinions that you give, for which you get lakhs of rupees, is based on this interpretation of statute. Without your knowledge, you are already following it. Because when I asked you every company, you told the correct answer. When I told a company, you told the correct answer. There are certain standards. Tell me, what are the sources of law or sources of statute? What would be the sources of our statute? From where will law come? Tell me guys. Constitution, 1 second. Just change the battery. Yes. So where will the law come from? Constitution. Okay. Now what I am saying is any new law has to be framed. Who will frame it? Legislature, right? Parliament. The legislature will do it. So one source of law definitely is legislature, no doubt about it. So they will form it. They will frame the law. So generally how law will be framed, first they will understand why there is a need for a law, and then they will frame the basic structure. One of the ministers only will initiate it, and then it will be given for public comments. Yesterday only we saw public comments. After public comments are over, it will be laid before both the houses of the parliament. So one round of discussion will happen, then it will go to the standing committee. For Companies Act and all, it is standing committee on finance. So there are various standing committees. They will go through it, again deliberate, again go back, then Lok Sabha will pass, then it goes to Rajya Sabha, same procedure. It takes years, some take, months, whatever it is. It depends on the intention of the government. So if you see, one is the legislature. Fine. Second one is what? Second one, second source of law. Adopt from other countries, but again it will go through the legislature only, correct? You adopt from other countries and you go through the legislature. For example, insolvency and bankruptcy code, we took from all other countries, but still we passed the legislature, correct? Insolvency and bankruptcy code. You may ask one question, sir, why isn't it Insolvency and Bankruptcy Act? Why is it Insolvency and Bankruptcy Code? They got bold, that's why they added code. We'll see that later. So that is legislature. Second, it is your judicial precedent. Judicial precedent means something that has not happened before, something which has happened for the first time. For example, basically the judiciary here pushes for you to change the law immediately. For example, best example is the Nirbhaya rape case, right? If you remember, immediately after that, so many laws changed. It was the IPC became very strict. So that was a 16-year-old kid who inflicted the most pain. But unfortunately, in our country or any countries for that matter, minors cannot be tried as majors. Correct? Law punishes the body or the mind? Simple question. Law punishes the body or the mind? Body. Law punishes the body. If I put you to jail for whatever it is, for however long it is, what do you think? Body or mind? We will discuss that. I'll have to give some history behind it. Later we'll see, because we have to finish this and then we'll come to that. So keep that in mind. Law punishes the body or the mind. Now, legislature, judicial precedent, second point. So Nirbhaya, they said that you have to ensure that the minor also will be tried as a major and he will be put behind bars. That's why they said that in heinous crimes, in most dangerous crimes, even if you are a 16 years of age, you will be tried as a major. So they changed that law. Then in Delhi and other parts of North India especially, there were a lot of bad things happening, including rape, murders, etc. behind these 100% opaque glasses in the car. The car had all black glasses. There was nothing you could see inside. So they changed the law. What did they say? It should be 70% transparent, only 30%. Correct? You should not have any of those things. Tinted glasses should be removed. You remember a few years ago that law was passed. So across India, tinted glasses were removed. That also was. So these are called judicial precedent. So that is also a source of law for sure. Third most important in our country, third most important thing. Simple question. Can you go to a temple wearing chappal? Today you try. Going to a temple. Can you go to a mosque using slippers? Today you try. The temple fellow will throw you out. He'll say, no, slippers are not allowed. Can you say why? Show me Temple Removal of Slippers Act. Show me. You are full law student, no? Can you tell all that? Why? Yes, it is a custom followed. It is a custom followed. Correct? So for you, for example, in the holy month of Ramzan. So you guys obviously at night when you break the fast, you eat fruits, right? Fruits and other things. Why can't you eat other things? Because it's the custom. There are reasons for each and everything. Age-old tradition. Your parents would have told you, no, don't cut nails, something on Friday, yeah? Which day? At night you cannot cut nails. Then, you can't go for haircut on Tuesday, all those things. You ask them why, they'll not have an answer. They'll not have an answer. It is an age-old custom tradition which is coming since ages. You have to follow. That's it. So most important in our country are honestly customs and tradition. This always there is a problem between law and customs. Always. Few examples, the triple talaq rule. There's a problem between law and customs. Second, Sabrimala. Are women allowed inside Sabrimala temple? Can they go? Again, customs versus law. That went to the Indian constitution level. There was a case. Eventually, what happened? Allowed. So it is always between law and customs. Customarily, the people who followed the custom said, there are many temples where women are only allowed, men are not allowed. There are many temples where only men are allowed. There are remaining all temples, everybody is allowed. Why do you want to come here and take away this custom? But the people who wanted to follow the law, pro-constitution, they are like, it is my right. Freedom of religion, liberty. I will do it. So if you see, this is a big problem in our country because we have so many religions, so many customs, so many tradition. Right? There are certain governments who, for example, have banned beef trade. You know which are the states. Right? So the other party is telling other parties who consume meat, it is, for me, it is a kind of meat. That's a valid question. For me, it is a kind of meat. Who are you to tell me what to eat, what not to eat? These fellows are telling the cow is our mother. So if you see again, customs. So if you see in India, it is very, very difficult because there are so many religions, so many customs, so many traditions, so many subcastes. So if, for example, even in this class, if I ask you this opinion, each person will have a different opinion. Then eventually we'll start fighting. That's what happens, no? So if you see, that is a huge problem. So they are all batting as of now for something called as Uniform Civil Code, which will never come in our country. Uniform Civil Code is every religion, everything should follow one civil law. So don't care about customs, it should be one uniform law, which will never happen in our country. It is not possible. Even within the same religion, the same caste, there will be various subcastes. So each subcaste, the customs will be different. The customs will be different. So the thing is, you cannot fix a uniform civil code for all these things. It will take ages. And anyway, that is the main point where the political divide will happen. So the politicians will ensure that people will be divided based on customs and tradition. So that's the thing. So if you see, these are the three sources of law, but still we have to recognize the third point. It is very, very important. Customs and tradition play a very, very important role in our country. This is the reason why there is no removal of Chappal Act and all. That is why we cannot remove, we cannot just go with chappals. There is this guy, Yesudas, do you know? Singer, very famous singer. So Yesudas has sung so many albums in praise of the deity at Guruvayur temple. So many albums, so much money he has donated to the temple. His only wish was what? What was his only wish? To visit the temple. Did the priest allow? No. The priest says in Guruvayur temple you have to be a Hindu only. Since you are a Christian, I know you have sung a lot, I know you have given a lot of many things here, but unfortunately you are not allowed. So in some temples, people from other religions are not allowed. In some mosques, people from other religions are not allowed. In some churches as well, people from other religions are not allowed. Is that any law? Is there any law like that? No, it is a custom. Can we go and fight against it? That is the question. There are how much will you fight? What will you fight? So whether by interpretation, misinterpretation, whatever you may call, these are customs and traditions of our country. So whether to preserve it or whether to form a uniform civil code is a debate which is going on from hundreds of years. And that is one of the, main reason why the British utilized it and divided our country. Divide and rule. They divided our country based on caste, creed, religion, right? That's how it is. So if you see, these are the three sources of law. Legislature, judicial precedent, and this is the most important thing, customs and tradition, which in India is followed. So it is the custom. So even when I used to ask my dad why I can't go for a haircut on Tuesday, he never had an answer. So I used to go on Tuesday only to rub it in his face because I was kind of a rebel that time. Even now I am. So give me a valid reason, then I will not go. Like for example, these Jain community do not eat anything that grows underground. Do you know that? Why? That they have a reason. Why? Because they don't want to harm any living organism. So anything that grows underground like onion, garlic, etc. has living organisms on them because it's beneath the soil. So they don't want to harm. And if you see the chaste Jain community, the Shwetambaras, Digambaras, if you see, they cover, some of them cover their mouth also. They don't want any living organism to enter their mouth. That is the highest form, extreme form. It's there, they are there. And I think Digambaras walk around naked because they don't want any worldly pleasure. They don't want any worldly item, no materialistic item. They are, human beings are born naked, live naked, die naked. That's their extreme form. Can you go and tell it is wrong? That's what I'm saying. If you see Gomateshwara, the statue, that's how it is. Can you go and say it is wrong? No. So what I'm trying to tell is we have to respect the custom and tradition of each and every religion. But then because of this political thing, we start fighting. That's the thing. So that beef ban, all these things are, the people who are for it will have pros and many pros. People who are against it will have many cons. So how to balance it out is a very difficult thing. But what I'm trying to tell is these are the three things which will guide the statute, and it is your duty. Why I told all this is your duty as a CA. Forget about the third point, at least the first and second point. When a client comes to you and says, sir, what is this? We should be in a position to answer that this is nothing but, this is right, this is wrong, this is the interpretation, this is what they meant, is what we need to tell. So if you see, interpretation of statute, there are various rules of interpretation. Whatever you did now, when you said every, when you interpreted the word did you use any extra brains or did you interpret it literally? When I use the word every company, did you interpret it literally or did you have to use any extra brains for it? Any extra rules that you figured out? No, just literal. So this rule is called litera legis. Litera legis means literal interpretation. This is what was there in inter new syllabus which we missed. Almost 90% of our law, is based on the rule of litera legis, means literal interpretation. So it's so easy. Almost 90% is based on litera legis, but still we will need people to help us out in interpretation. Almost 90% is on litera legis, means direct interpretation, no seeing any other rule. During the course of the classes, we will be discussing the various interpretation rules. So the first rule is litera legis. During our classes only we will be discussing. These are the rules that you have to know. This is the reason why you become the decoders of law. Each and every section line you can decode. That was the most important chapter. Stupidly they put it to inter and they made it so complicated in inter that no inter student will study. It is not the inter student's mistake. It is the institute's mistake. They should have retained it in CA final. But by putting it in CA inter, imagine what they are expecting. They are expecting you to study all this in CA inter only. So that when you come to CA final, we already would have studied all that. And this is just a application of those rules. But expectation versus reality, we know, right? That's the thing. So if you see litera legis, 90% literal interpretation, which means that most of the important areas of CA final have been shifted to inter, which shows that what the institute is expecting these days. So we need to be up for it. Yes. Online fellows, good morning. Full slept off. Not to be seen only here. Yes. So litera legis, literal interpretation, 90% of the thing. They are there. Thank God. Yes. So if you see, done. Still I have not answered. From somewhere and all I am going, full round. We still haven't come to the point only. This is like some Ekta Kapoor serial going everywhere else. Yes. The board of directors of a company. So two things we learned. We understood what is board of directors. Second, we understood who is director. Then we understood a new rule called litera legis. A company, literal construction. Every company. Every company means every company. Very simple. Shall be, again, litera legis. Shall be always means what? Mandatory. There may be some cases where it is reverse, but for now it is mandatory. Entitled, litera legis. Entitled means right. To exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. Means what they are saying here, in 179 they are saying, in simple words, whatever the company could have done, if company had brains of its own, who can do? Board or shareholders? Board. Whatever the company could have done, if company had brains of its own, can now be done by board of directors, can do those things. Which means, in simple words, can I say, the board of directors are the brains of the company. They are directly telling 179.1, whatever you can do, whatever the company could have done, can be done by the board. If you read again now carefully, you will understand. The board of directors of the company shall be entitled, they have the right to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. Whatever the company could have done, can everything be done by board? It's like a blanket, what do you say, approval. You can do whatever the hell you want. Whatever the company can do, you can do. Then what will shareholders do here? Only investment? So we know that shareholder, if the board is at the center, if the company is at the center, shareholders would of course invest, board of directors would manage, we know that. Company will give the return to shareholders as dividend. If board are the brains behind the company, what are shareholders? Limbs, hands and all, let's not tell. What are shareholders then? Yes. So if you see, this 179 is called the mother section. And generally, as we all ignore mothers, this is also ignored. Nobody studies this section. So the board of directors of the company shall be entitled to exercise all such powers and to do all such acts as the company is authorized to exercise and do. Okay. Then we'll see. Again, interpretation of statute comes. Provided. What do you mean by provided? Provided is called a proviso. Again, I am invoking interpretation of statutes. Provided means proviso. Proviso, what does it do? It either adds on to the subsection or it gives an exception. It either adds on to a point or gives an exception. Correct? It either adds on or it gives a exception. The question paper was very easy, provided that few questions were dead easy. Means what? I am just adding on. I know it's easy, but some though are very easy. The question paper was easy, provided some questions were really tricky. Exception. Simple examples I am giving. Right? That's the thing. Right. So a proviso adds on or gives an exception. Generally in law, any provisos can be there, any number. So for every subsection, if I use the first proviso, it's called provided that. If I use a second proviso, they will give provided further. If there's a third proviso, they'll say provided also. Fourth one, also. Further also. What? Fourth one is also. After this, whatever you put, it's only going to be also. Best example is your 139. I'll just show you here only 139. You would have studied in Inter. Here, provided further, provided also. Provided that was there, it's removed actually. Provided that was there, it was now removed. So technically this should have been provided that, but anyway, they have not changed that. So first, this was provided that already, then provided further, provided also. So while reading, how will I read? The first proviso has been deleted. This is the second proviso, third proviso, fourth proviso. So if you want to impress your client, you can say, sir, according to the fourth proviso of subsection 1 of section 139 of Companies Act 2013, that fellow will say, sir, all that you don't want, you write that opinion and give me. Correct? That's the thing. So if you see, that's the thing. So while in the exam and all, no need to write all those things. Fourth proviso of subsection 1 of section 139 of Companies Act, that is all waste of time. What can you write? 139(1), fourth proviso. That's it. Quickly. And proviso number, which proviso also really not needed. It's fine. If you can remember, great. So it's, you can just simply cite 139(1) as per 139(1), fourth proviso. Over. So no need to write everything. Right. So if you see, first we have already discussed board of directors means what, we have discussed directors means what, then we have understood litera legis, then we have understood fourth thing, board of directors are the brains behind the company. Now shareholders are nowhere in the picture, so I have to bring in shareholders. That is why I will see the first proviso, you ignore, second proviso. Please read, then I will discuss. Read. Yes. So it says, board shall not exercise any power or do any act or thing. Is it an exception or addition? Exception. Why? Point number 1 said board can do whatever the hell they want. Now they are telling board cannot do those things. Cheating, no? Right. So if it says board cannot exercise any power or do any act or thing which is directed or required, whether under this act or by memorandum or articles or otherwise, to be exercised or done by company in general meeting. In CA Inter we have mucked up, general meeting means shareholders meeting. So here suddenly an exception has come. What is the exception? In the exception they are telling, board of directors cannot do those things which shareholders can do. In general meeting. I repeat, board of directors cannot do those things which shareholders can do in general meeting. Whatever shareholders can do in general meeting, Who cannot do? Board cannot do. You read, that's what it says, correct, no? I'll remove this. Board shall not exercise any power or to do any act or thing which is directed or required, whether under this act or by memorandum or articles or otherwise, to be exercised or done by company in general meeting. So whatever the company does in the general meeting, shareholders, but it has to be authorized by three things: articles of association, memorandum of association, or it should be authorized by the act. Articles of association, memorandum of association, all CA inter-syllabus now. Basically they are telling, if articles or MOA or act give the power to the shareholders, who cannot do those things? Board. Board cannot do those things. Obviously we have to take some examples, otherwise we will not understand. We will take them now. So here they are saying, whatever the board of directors, whatever the AOA, MOA or act gives the power to whom? If they give the power to shareholders, then can board interfere in that? No. Board cannot interfere. Which clearly gives a two-tier mechanism here, whereby if certain things are to be done by the board only, then who should do it? Board. If certain things are to be done by shareholders only, who should do it? Shareholders. Board cannot interfere in what shareholders can do. Shareholders cannot interfere in what board can do. Obviously, you have to see some examples. Coolly, we will see one by one. Again, don't be worried about the section number and all that. Later, we will see all that. But examples. First example is 179.3. Here only, 179.3. The board of directors of a company shall exercise the following powers on behalf of the company. See, everywhere, company can be shareholders also, company can be board also. But general understanding means company means shareholders generally. But here, the board of directors of the company shall exercise the following powers on behalf of the company by means of resolution passed at the meeting of the board. Means they are trying to tell, if any of these points are there, to make calls on shareholders, to authorize buyback, to issue securities, to borrow money, to invest funds, to grant loans, to approve financial statement. If you want to do any of these things, how should it happen? Board meeting resolution. Now tell me, simple question, can shareholders interfere in any of these things? No. Why? It is being given only to the board. If it is given to the board, can shareholders interfere in any of these things? No. So it's very, very simple. The act has given power to whom? Board of directors. So for example here, for instance here, under 179.3, who has the power? Board of directors have the power. Shareholders have no power. Shareholders cannot interfere. At any cost they cannot interfere. Act has explicitly given the power to whom? Board. Act has explicitly given power to the board. There are certain things where board has no power, only shareholders have the power. For example, again, I'll check 169. Removal of director. Can director remove one more director or shareholders? Shareholders or director? Shareholders, no, correct. A company may, by ordinary resolution, remove a director. That only is enough. Whenever I use the word ordinary resolution, it means general meeting. And general meeting means shareholders. A company may, by ordinary resolution, remove a director. Here may means what? If they want to remove, they can remove. Can director interfere in this? No way. Can directors interfere in this? No way. Cyrus Mistry, director, was removed by Tata. Can Mistry interfere in that? No. But still, the case is in Supreme Court. Why? Because he said the procedure was not followed. The correct procedure was not followed. Just like that, they threw me out. So the correct procedure has to be followed, right? Supreme Court still going on case. Cyrus Mistry versus Ratan Tata. So the company may, by ordinary resolution, remove a director. You will have a right only if the procedure is not followed. You will not have a right where they'll say, why are you removing me? The way you removed me was wrong. Why are you removing me? It's your right, boss. You remove, no problem. But you should have done it in the right way. So company may, by ordinary resolution, remove a director. Coming here, 169. Power is only with the shareholders. Board of directors don't have power. This is what, guys? Removal of director. Now one question. If the act doesn't give the power to shareholders also, board also, then who will do it? I'll give you an example, you tell me the answer. See, here though directly it has given to board in 179.3, in 169 it is given to shareholders. There can be some cases where the act is silent, then who will do? Board or shareholders? Board. Check it out, I'll give you an example. Notice of the meeting. Who will give the notice? Board or shareholders? Nothing is given in the act. Board. 1011, general meeting may be called by giving not less than 21 days notice. Who will give? God only knows. Board or shareholders? Why board? Yes, that's all perfect. You are only interpreting everything, correct? All activities which the company could have done, if company had brains of its own, will be done by board. So this is one example, notice of the meeting. Then you have to give some explanatory statement. Who will give that explanatory statement again? Board, because the act is silent. So that's the next section. 102. Statement setting out the following material particulars concerning any item of special business shall be annexed to the notice. That's it. Who will annex it? God only knows. So there are certain things where the law is silent. When act is silent. Example 101, 102. 101 is what? Notice of the meeting. 102 is what? Explanatory statement. I told you section numbers, you need not know everything now. You may get confused also. Don't get confused. I already gave you a disclaimer. What is this fellow writing 101, 102? I'm not able to understand anything. It's okay. 2 days you will not understand anything. But one thing you will definitely understand, concept. I don't know which section, but I know for sure if act is silent, board of directors. I don't know section number and all, leave it. That's okay, no problem. Online friends, following? Yeah. When act is silent, who will do it? Yes, board will do it. Because of that general dialogue in 179.1. Because of general dialogue, whatever the board company could have done, if company had brains of its own, who will do? Board. Very, very simple. Board will do it. Done. There are some times when the act requires both of them to do it. Jugalbandi. You also do, I also do. Together we'll do it. That also is there. Just a simple example, section 180. What is 180 and all, you leave it. Just an example for your knowledge, that's it. Anyway, during the course of our classes, you will understand all these things, no tension. The board of directors of a company shall exercise the following powers only with the consent of the company by a special resolution. See, what is that you leave? For example, selling of undertaking. If I want to sell one undertaking, means one of my branches if I want to sell, not only the board should agree, but also company. Company, when I use the word special resolution, it means general meeting. So what resolution? Special resolution. So the board of directors of the company shall exercise the following powers only with the consent of the company by a special resolution. There are certain things, for example, in 180, where shareholders plus board should do it together. Even if one person doesn't do, gone. So that's the beauty of law. Certain powers only given to board, certain powers only given to shareholders, certain powers both have to do, and a fact is silent, board. Fact is silent, board. But if you compare powers of the board and powers of the shareholders, powers of the board, they say you do whatever you want. But powers of the shareholders, they have told it is only restricted to AOA, MOA Act. Correct, no? Powers of the board, they say you do whatever you want. Powers of shareholders, they say AOA, MOA Act. What do you mean by AOA? What is AOA? Articles of Association. What does it do? What does AOA do? Is it the AOA, MOA both are constitution of the company or what? Yes, AOA, MOA both form the constitution of the company. AOA speaks about the internal regulations of the company. Bylaws, correct. Internal regulation. How should the members behave? What are the rights of the members? What are the rights of the directors? What are the powers of the directors? Can I restrict certain powers? All that is given in the articles. MOA is what? Relationship between the company and the outsider. What is the name of the company? What is the objects of the company? What is it liable? Is it limited by shares liability? Limited by guarantee? How it is? That is called MOA. We will explain that slightly later because there is this concept here, no? Here, page number 37. Member, AOA, MOA types of companies. All these things which we had to study in Inter, we amazingly studied and we have come this stage here. So we need to unlearn those things and learn again. It's absolutely fine. I am not blaming you at all. I was worse than you. I told you 42 I got. So, and the concepts are also very, very weak that time. So there is, and that time I realized that if at all I become a teacher, I will ensure that the first 1 or 2 classes will be complete basics because we actually have not studied it the way it has to be studied. All these things actually should be studied in CA Inter. CA final, I should directly start off with disqualification of directors. But I spend 1 or 2 classes to ensure that these things are drilled down so that it won't be problematic for you in the future. Yes. Now this is done. My next question is, can AOA and MOA override the Act? Here only I'll ask that question. Can AOA and MOA override the Act or is it the other way around? Can AOA, MOA have certain provisions which will go against the Act itself? No. Act is supreme or AOA, MOA? Act. So you would have seen this dialogue. If Act is there, inside the Act, MOA. Correct, no? Inside the MOA, AOA. Yes, you would have seen doctrine of ultra vires, doctrine of constructive notice and all these things. Indoor management. So, if we see This dialogue, section number 6, clearly tells act to override memorandum articles. So we read that section 169, which said the shareholders only can remove a director. Can I insert in the articles director also has to approve? No. This dialogue, act to override memorandum articles. Here, the provisions of this act shall have an effect, notwithstanding anything to the contrary contained in the MOA or AOA. They say, even if something ulta is written in MOA and AOA, I don't care. Who will apply? Act. Act will apply. So, section 6. Act to override AOA and MOA. Act to override AOA and MOA. Online, any doubts? Act to override AOA and MOA. Now, one interesting example I will give you. Section 103. Again your CA inter-syllabus quorum. Quorum of what? General meeting. (103). Here, quorum is the minimum number of people required to transact valid business. So, in case of public company, it says 5 members, 15 members, 30 members, all that. 5 members personally present if the number of members is not more than 1000. 15 members if the number of members is more than 1000 but up to 5000, all that. Okay, all fine. But see this line. Unless the articles of the company provide for a larger number. So instead of 5, can the articles provide 20? Yes. Isn't the articles overriding the act? No. We just told one dialogue now. Act is supreme. What do you think? The provision is given in the act itself. So how can articles override the act? Act only is telling articles can go higher than me. So there are certain peculiar cases. For example, this one, where articles can fix larger quorum. One more slightly different example. (63) to A, 68 to A. 63 to A is bonus, 68 to A is buyback. Don't be worried about section numbers. Repeatedly I am telling you, do not get worried. You get full tensed. Oh, what all these sections, I've never studied, all that. Don't worry. As long as you understand the concept, I don't care about section number. 63. Issue of bonus shares. No company shall capitalize its profits or reserves for the purpose of issuing fully paid up bonus shares unless it is authorized by the articles. Means what? If articles are silent, articles don't authorize at all, can I issue bonus shares? No. Is articles overriding the act in some way? Act only is giving power. Act is telling, boss, this is the section for bonus, but this section will not at all apply if articles is silent. Weird, different. Then similarly 68 buyback. 68 2. No company shall purchase its own shares or other specified securities under subsection 1 unless buyback is authorized by the articles. 68 says this full buyback section is there, but this will only apply if the articles authorize. So in these cases, in both these cases, section will not apply. Section will not apply if what? If articles are silent or articles authorized? If articles are silent. If articles are silent. These are the cases where, peculiar cases, Act gives power to the articles. Our Act gives power to the articles to sort of override the figures given there in the Act. What are the figures given in quorum at 5, 15 and all that? Those figures, can it be overridden? Yes. By entering what? Larger number in the articles. Who gives the power? Act. Weird. Are you understanding? Act gives the power to the articles to kind of override certain provisions, like the figures, numbers. Not the full Act, but some numbers and all those things. This is a very peculiar thing. But isn't it going against my section 6? Section 6, what does it say? Act to override articles. Isn't it going against section 6? Provisions of this Act shall have effect notwithstanding anything to the contrary contained in the memorandum. But see this deadly line here. This also you will encounter in many places in law. Save as. Save as means except. Except. Except otherwise expressly provided. Except otherwise means ulta. If ulta is given. How ulta will be given? Expressly given. What is the general rule? General rule is this. Act will override the articles. Act will override the articles. This is the express provision. But, I mean, this is the provision, actual provision. But in those cases, that's why I said except. In those cases where ulta is given expressly. What is ulta? Articles overriding the Act. Where is it given? 103, 63, 68. Some examples. In 103 it is given, articles can fix larger number. Act says 5, 15, whatever. Articles say 20, 30, 40, 50, your wish. That comes under this save as point. 63 gives provisions for bonus. But that entire section will apply only if the article says so. Where does it say? Expressly given in the Act itself, 63. 68, buyback. Buyback provisions are beautifully given in 68. But buyback provisions will never apply if articles are, if the Act is given the power to the articles. If articles are silent, buyback you can never do. When can you do buyback? Only if it is mentioned in the articles. So is articles overriding the Act? Yes. Who gives the permission? Act. Weird. That is covered in this one line, which we will not even read. Save as means except. Otherwise means ulta. Expressly given means it should be given in the Act. Where is it given? 103, 63 2A, 68 2A. You may not remember the section numbers, but you will definitely remember the concept. Right? Yes. Parth, you are right. He has answered it. In section 6, words are save as otherwise. Correct. You are right. Save as means except, otherwise means ulta. Reverse. What is the general rule? Act overrides the articles. What is the ulta rule? Articles override the act. But where is that given? Expressly given in the act. Beautiful. So this entire dialogue is this line, save as. So this line is nothing but in section 6, save as, otherwise expressly provided in the act. Yeah, tell me. Ultimately, power is given in the act itself. It overrides some numbers, not the act. For example, the figures 5, 15, isn't it overriding the figures? Yes, that's what I meant. It doesn't override the act. Correct, she's right. It doesn't override the act. It overrides certain provisions. Like for example, the figures 5, 10, 15. I want to do more than that. Act is telling only 5, 10, 15. Can I do more than that? Yes. Where? Articles. Can articles give a lesser number? No, because it clearly says larger number only. If you see 103, for example, it uses the word larger number. So the articles also should be well within the law. Articles can't tell whatever they want. See here, unless the articles provide for a larger number. It doesn't say articles provide for any other number. Then in that case, I'll put 2 members here. It should be more than 5, it should be more than 15, it should be more than 30. It doesn't override the act as such, it overrides certain provisions. In this, it overrides the numbers. That's all. So that is the scene. Still it didn't answer my question. What was my question? Who is more powerful? Still I don't know. Correct? So maybe after one cup of coffee, we will answer that question. So take a break, 10 minutes. Did you understand till now? Online friends, did you understand? So we still have to understand who is more powerful. This has not answered anything, because this has told board can do whatever they want, shareholders can do whatever is given. It still hasn't answered who is more powerful. What if act has given more powers to shareholders? We don't know. So it still doesn't answer our question, which we will understand after the break. Scroll up chart. Okay, hold on. Which one, man? Is this fine? Yeah, done. So take a break, guys. Which one? Vivek, is this okay? You guys can go. Just take a break. Below. Some more. Here. Right. Done. Alright guys, it's still not clear for us who is more powerful. So that is what we'll check now. So somewhere here you have to make some space and write if possible. I don't have space. If you have written here somewhere, yeah. So simple question: you are let's say 100% shareholder in a company, right? You hold the full shares, everything 100%. You go to the company secretary will welcome you, all that. You'll ask how are things going. He'll say fine. So will you have coffee? Yeah, coffee. Will you have dosa? Dosa. Everything done. After that, after eating and all that, he'll later say, okay, you will say you're 100% shareholder. No, I just want to see the accounts. It's December now. I'll want to see the accounts. Can you show me the accounts? So the company secretary says, sir, you've eaten properly. No, no, I think you can leave. You will say, boss, how dare you talk to me like that? I'm a 100% shareholder. The chair that you're sitting is owned by me. The laptop that you're working is owned by me. The entire building is of course owned by me. Every rupee that the company has was given by me. I am just not saying I'll do anything. I just want to see the state of affairs. I just want to see what is the profit figure. At least tell me that. Show me that. I just want to go through. I'm not going to eat you up. I just want to brush through the things. Because it's already December and there is this COVID and all had happened. So I just want to see how things are. So that fellow will say, sir, I repeat again, you have eaten properly, I have looked after you. That's all I can do. You can get out. Is the company secretary right or the shareholder? Shareholder says, I'll go to the court. I'll go to the police station. Company secretary says, you do whatever the hell you want. I don't care. What do you think? Who is right? Shareholder or company secretary? Company secretary. You can't check the accounts as a shareholder. Financials, or you can't check the accounts here and there. Why? Power is given to board to do what? To check accounts. Inspection of accounts. So you're right. 128 if you see. Books of accounts. Again, CA enter. Books of accounts. 128.3. The books of accounts and other books and papers maintained by the company within India shall be open for inspection at the registered office of the company or at such other place in India by any director. By any director. Even one director can ask for the accounts, but can one member ask for the accounts? No. The books of accounts and other books and papers maintained by company within India shall be open for inspection at the registered office by any director. Does shareholder have the power to inspect the books of accounts? No. Shareholder has no power. So if you see, because of 128 subsection 3, shareholder has no power to inspect. Useless is. After this juncture, I'll ask you this question at this juncture. Who is more powerful, board or shareholders? Chopper fellow can't do anything. He can't go check accounts also, poor guy. What do you think? Still it is doubtful. But now probably you may feel directors are more powerful. Probably. Tell me. RTI. Inspection of the book accounts as of RTI. So what information do you need is the question. Certain things you can, if the act allows you to do that, certain things yes. But if you are not entitled or you don't have the right to file for it, you cannot claim the documents. So for RTI, if you need certain instances of what, you cannot ask them where you invested the money, what did you do with this money, what were the thinking behind it, that and all you cannot do. Correct? But if you need certain documentation as to, you have already invested, I need more information into it, definitely yes, that you can. Right? So that is the reason why that act also came into force, to give power to anybody for that matter to ask for information. Predominantly in these, even ICAI for example, we have no clue what is the pass percentage, everything. So, and how many people appeared for it. So those information, that data which generally is not projected, can be given. So under RTI, in fact, even one student, his name is, I forgot his name, he's in Andhra Pradesh. So he has, Vinod Reddy, yes. So he has done many things for the students where he has extracted all the information, how many people wrote, what was the pass percentage, how many people got exemption. These things institute doesn't release. So those items under RTI he has extracted. So yes, those things can be done. But the confidential items as to give me the board minutes, what was discussed at the meeting, all those confidential things which only the auditors can see anyway, that obviously it is not open to public domain. So tell me the conversation between Cyrus Mistry and Ratan Tata, show me the board minutes. Those things obviously will not apply under RTI. Clear? Yes. So now under this 128(3), no power. So shareholder went and told, what is this? I am the investor, it is my company, you tell that I am the owner, and now you have not given me any powers. So MCA says, chill man, don't worry, you have so many powers, especially 4 very, very important powers, which you only don't know. First power is under 152(2), read with 160. Section number and all, leave it, doesn't matter. 152(2) read with 160. This is appointment of director. You are coming and complaining that director can inspect accounts, you can't inspect accounts. Okay. Who can appoint director? You only. So appoint somebody who you trust, no? Why are you dying? Is what they are trying to tell. 152(2) read with 160. So if I just show you 152(2), 160 is the procedure of appointment, 152(2) is the charging section. Every director shall be appointed by the company in general meeting. Every director shall be appointed by the company in general meeting. That's it. Other things save as and all we'll see later. So every director, how will he appoint? In the general meeting. So who has the power to appoint? This guy. Then they say, okay, I thought he was trustworthy, but he was not trustworthy. Can I change him? Can I throw him out? Of course, we have already seen section 169. We saw 169 already, right? 169. Who can throw out the director? Shareholder only. Company may, by ordinary resolution, remove a director. Not only appointment, even removal is under your power, MCA told shareholder. Then shareholder say, but they can inspect accounts, why can't I inspect accounts? I want to see the accounts. I want to check what is going on. So MCA says, shareholder, you don't have the caliber. For that, you have to die for 5 years, correct? After dying for 5 years, you will be reborn. You will be reborn, and once you are reborn, you can go to that person who is reborn, who was after dying, who has come out, and you can only ask that person to do it. Who is that person? Auditor. Right? So the MCA says, go to Malleshwaram 7th Cross. There is the CTR hotel, have a dosa there. Then have bite to coffee, one coffee, and wait for some time. People from the basement will come out. So catch hold of them. They really have the caliber. So what is that? Section 139. 139. Appointment of auditor. Who has the power to appoint auditor? Only shareholder. The first auditor can be appointed by a board, that we will see. Auditor's provision, some in-depth discussion of 25 hours or maybe 20 hours is, I had done it as part of the old syllabus, but that is now for you where it is in CA final auditing. So that part also I will share the videos, don't worry. That will help you in auditing, not in law. In law it will not come, but it will definitely help you in auditing. That in-depth discussion of 128 to 148, 20 sections. I think it's some 20 hours. It will definitely help you, full in-depth discussion. So I will share that also. Anyway, you're getting this view, right? In that I'll share that. So 139, appointment of auditor. Then, sir, you told me to go to 7th cross. By mistake, I went to 15th cross. Instead of CTR, I was having at Veena stores. So there also some people were coming down. I went and spoke to them. I didn't like them. Can I throw them out? Can I go back to CTR and from the basement people are coming? Can I go back again? Yes. What is that? Removal. Section 140. Removal of auditor also is the sole power of whom? Shareholders. So if you see 140, the dialogues only, that board is not allowed at all. No board seen. That's all. The auditor appointed under section 139 may be removed from his office before the expiry of his term only by a special resolution. Chapter close. Nobody else has the right. So they are telling, boss, I am giving you the power to appoint the director who can prepare the books, who will appoint the management, accountant and all and prepare the books. You don't like him, throw him out. And you don't have the caliber to check accounts. For that you have to die. 5 years you have to, in rigorous tapas. After tapas, they have that degree. Once that degree certificate is there, qualification, go to them. You don't have the caliber. But I am also a chartered accountant. I am a shareholder. No, you don't have the, you maybe have the caliber, but you don't have the independence. So go to those guy who is an independent auditor. So go to them. Then they will follow all the standards on auditing. They will follow all the standards and they will, certify on a piece of paper which has all the figures. He will sign, and that will be called as the audited financial statement. So when he or she signs that, it's called the audited financial statement. That is proof for you that he has gone through everything. You can trust that person. I don't like the way he did work. Throw him out, 140. So those 4 heavy duty powers, these are called as the 4 pillars of corporate democracy. Inside is warmer than outside. For coffee I stepped outside like some 17 degrees or something today, 17, 18. Here only it's some 27 degrees. Inside is warmer. So 4 pillars of corporate democracy. This is corporate democracy, 4 pillars. These pillars are governed by you. You are the center, you are the foundation. So don't crib. So now if I ask the question, who is more powerful? You can say that for day-to-day operations, shareholders will not interfere. Who will do? Board. Whatever the company could have done, if company had brains of its own, who will do? Board. But main overall 4 powers of appointing the person who does that day-to-day affairs and also appointing an auditor who is going to ensure that all the books are in place, are fine, is to be done by whom? Shareholders. So still you cannot say who is more powerful. It is a clear-cut 2-tier mechanism. For day-to-day operations, board. For overall, it is the shareholders. And if the act is silent, that means it is normal operational issue. It will be done by the board. So they say you build the foundation, sit back and relax. Director will, if it's like a building. In a building, you are the foundation. You have built everything. Director will change the interiors. You can't question. Director will buy one new chair, throw out one more chair. Day-to-day operations. You can't question. Director wants to sell one floor. Then you will come by selling of undertaking. Remember? Section 180, both should come, board as well as shareholders. So powers are given whereby if it affects in a very large way, I have only given you powers where you can interfere, but otherwise there is no need. So this is the beautiful mechanism, 4 pillars of corporate democracy. So technically in one meeting, what do you need? First of all, you need auditors. Then of course you used to check the accounts properly. Then you will appoint directors. And the reason why you have invested, obviously, one of the most important reasons is you want dividend return. So dividend. These are the 4 main things that I want, and these 4 things are called as what? Ordinary business. If you remember at the annual general meeting, it is coming from this only, no? Directors, auditors, and what would the directors do? Accounts, and ultimate return is dividend. So these are called that's why these 4 are called as the ordinary business that happens at the annual general meeting. Annual general meeting. Ordinary business that happens at the annual general meeting. Right? That is called ordinary business. So it all stems from the pillars of corporate democracy. So these are the 4 pillars of democracy. 4 pillars of democracy. Corporate democracy. Which one? Oh, sorry, my bad. 169. Correct. 169, removal. 152, 2 read with 160, then 169, then we have 139 and 140. 4 pillars of corporate democracy. Auditors, then this comes anyway. These things, auditors, accounts, dividend, and all these things will anyway come. Auditors, accounts, directors, dividend, that anyway will come. That's it. So we can safely say, okay, this can come here. I mean, you would have written down somewhere. So if you see here, who is more powerful, shareholders or board? Depends. So in some cases it is shareholders, some cases it is board of directors. Depends. Online friends, understood? Tell me. Tell me. Shareholders are powerful in the whole sense of the term, where they can appoint and throw out directors and all that, yes. But can they interfere in day-to-day operations? Let's say the company wants to invest in certain funds in some company. Can shareholders come and say, why are you doing it? No. If you see, for example, that investment I told you, no, we had seen this, what happened? New version is horrible. Old version only was good. If you see 179 we saw, in that one of the points was investing the funds. Huh, 100%. That's why you appoint, no? See here, investing the funds of the company. In 179.3, it should only be done by meeting at the board. So you appoint people who you trust. And when they are investing your funds and all that, don't question them. Why are you investing? Boss, you have already appointed me. Let me do my job. Then if you don't like him, anyway, you can throw him out. So you cannot question their day-to-day activities. Then it will be like a never-ending thing. Everything that they do, if they have to seek your permission, company will never run. How they invest, when are they issuing securities, how much money they want to borrow, when are they borrowing, to whom all they are giving loans, are they making calls on the shareholders' funds, are they issuing new shares, are they issuing buyback, all those are pure decisions of the board. You cannot interfere. But if you go to those respective sections, if it crosses a certain limit, then shareholders also can interfere. If it crosses a certain limit, until the limit, it is the board. So ultimately, it's like very simple, guys. You are powerful or Narendra Modi? Simple question. Can you go to 10 countries in a month, Aram say? No. It is whom? Modi is powerful. Who appointed Modi? Simple. So once you appoint a person, you have to sit back and relax and trust that person. He will do the job. You cannot interfere. Now, if you don't like the government that you appointed, you can elect next time somebody else. It's up to you. Same democracy here also. Once you appointed me, let me do my job, don't interfere. But if you don't like the way I do it, please throw me out. By all means, I have no problem. Right? That's how it is. So that is the scene. That is the scene. So these are the pillars of corporate democracy. Everywhere it's the same. Yeah, so that is the scene. So still we have to understand what is this AOA, MOA and all these things. So let's just quickly, try and do all those things so that then we can go into the other areas of business resolution notice. Many times you would have seen business, you would have seen the word resolution, you would have seen the word notice. So you may not have realized what it is. So it is important for us, and of course the other types of companies anyway. Okay, we can do we can do this businesses, resolution and notice, and anyway we'll link the other parts later. Tell me guys, you would have heard and you will be hearing these words very, very often. You would have heard something called ordinary business, special business. Ordinary resolution, special resolution. Ordinary notice, special notice. Have you heard or not? Yes, tell me now. Is each set, this we'll call set number 1, set number 2, set number 3. Set number 1 related to set number 2 or what? Or all are different? What I'm asking is, if I give some ordinary notice for a meeting, should that resolution be ordinary resolution? And should that business be ordinary business? Is it linked like that? Or all 3 sets are different and there can be any combination of any set? This is all CA inter-syllabus, which we did not study properly. It is not your mistake. I will blame your teacher, whoever it is. If it is me, I'm sorry. But thing is, because these things have to be taught in inter. And this I actually teach in inter only. But in final, one special 1 day or 2 classes will be on this only, because in future we'll see this only. Ordinary notice, ordinary resolution, special resolution, you should know what it is. So to be very honest with you, okay, what are the types of general meetings that are there? Annual general meeting, then one more, extraordinary, that's all. Actually there are only 2, correct? General meetings are only 2 types. One is annual general meeting, where those 4 points that you do happen, right Vivek? And one more is EGM. Believe it or not, when I was in inter, I thought there were 3 meetings. One is AGM, one more is EGM, one more is OGM. What is OGM? Ordinary general, I am not joking, really I am telling. I thought there were 3 meetings. Annual general meeting, extraordinary. When extraordinary is there, ordinary also should be there, no? Ordinary Mysore Pak, special Mysore Pak. Ordinary dosa, special dosa. So when special will come only when there is ordinary. So I actually thought like a fool, AGM, EGM, OGM. This is what you will get when you read only textbooks. This is what you will learn. That's why all my mistakes I ensured I took a vow that I will not make whoever it is I am training repeat all these things. Even if at a final level it's okay, but we should know these things. So actually there are only 2. AGM, EGM. OGM and all is not there, right? That's the thing. So if you see ordinary business, special business, all this, actually nothing is linked. This set is a separate set, this is separate, this is separate. So one by one we need to see. So let's start with the business part. Only the business part. Tell me, what do you understand by ordinary business and special business? Day-to-day activities is ordinary business, okay. Selling some asset. Is it like that? Or is business an item discussed at a general meeting? What is business in the context of law? Is business an item discussed at the general meeting, or is business means like whatever he said, day-to-day activity, is that business? When it comes to law, yes, items discussed in the general meeting. Items discussed at GM. And now we have already seen there are 2 types of GM, AGM, EGM. So at every annual general meeting or extraordinary general meeting, we need to categorize. Actually, annual general meeting is nothing but ordinary general meeting. Why? 4 things I always have to discuss, boss. Corporate democracy pillar, auditor, accounts, director, and why am I here? Dividend, give me. Those 4 are ordinary items. Ordinary items there that anyway every year I have to discuss. What can be extra if I am selling an undertaking? Remember, I am amalgamating with some other company. If any of the provisions increase their threshold and the act says shareholders approval is needed, then I will have to come. So basically ordinary items are only 4. So those 4 ordinary items are given in section 102, which again I repeat is your CA Inter. More or less. (1022) consideration of financial statements, declaration of dividend, appointment of directors, appointment of and fixing of remuneration of auditors. So basically accounts. Accounts is nothing but what? Financial statements. Where did the eraser go? Accounts means financial statement. Then dividend. We have the dividend portion. Then I need what? Directors appointment. I have to appoint the directors. And lastly, who else I should appoint? Auditors. If you see, these are the ordinary business which we have already seen in the previous discussion, pillars of corporate democracy. Now these points, generally in a meeting in Kannada we say come to our usual adda, correct? Or if you like Saurav Ganguly, you say Dada, right? So because at one point of time, if you like cricket, Saurav Ganguly was the person who changed Indian cricket. Some stupid players were there before. He was the one who completely changed. And the match fixing scandal and all used to happen. Azharuddin was thrown out and Ganguly came in and he changed the face of Indian cricket. And he did it as if it was very ordinary for him, whatever it was his job. So if you like Saurav Ganguly, you can use the word Dada, or if you say come to our local Adda to discuss same Adda only. Accounts, dividend, directors, auditors. Accounts, dividend, directors and auditors. So if you see ordinary business, Adda points. Accounts, dividend, directors, auditors. Adda points. Now the question is, if I appoint a director at extraordinary general meeting, is it also ordinary business? If I declare dividend at extraordinary general meeting, is it ordinary or special? Ordinary business means only Adda points happening everywhere. These Adda points happening either in AGM or EGM, or Adda points happening at AGM only. So for example, if I appoint a director at an EGM, one director died, so I have to immediately appoint. I can't wait for the AGM. I'll call an EGM and appoint a director. Is that ordinary or special? You read, you only read and tell me. I will open 102. Your answer lies here only. Both. Online people are saying only AGM. Offline people are telling both. Read and tell me. Online people, please tell me the logic for the answer. Sorry? What special? It's a special. Why? Where? In the case of any other meeting, all business shall be deemed to be special. In case of annual general meeting, all business shall be special. Other than means these four are ordinary. In an AGM, everything else is special except these four. Means these four are ordinary. But in case of any other meeting, which is nothing but EGM, all business shall be special. All includes these four. Are you getting my point? All includes these four. So very, very simple. If the Adda points are happening at AGM, that is the most important thing. Only then it is ordinary. 102 subsection 2 clause A. 102 subsection 2 clause A. Subsection 2 clause A. Accounts, dividend, directors, auditors. The 4 points happen at AGM, then it is called ordinary business. Then what is special? Other than Adda points? Where? Other than Adda points in AGM is special. Okay, then? Adda points in EGM? Special. Other than Adda in EGM? Special. That's all. So this is perfect. 1022A and B together as per whatever you told. So if I say these are Adda points at EGM, then of course other than Adda at EGM. Means what? All points in EGM is special only, no? All points in EGM is always special. All points in EGM is special anyway. So ADDA points at EGM other than ADDA at EGM will be special business. Then of course what? Other than ADDA at AGM is also special. Other than ADDA at AGM is also special. So basically, rather than remembering special, you just remember ordinary business. What ordinary business? ADDA at AGM is ordinary. That's it. Everything else is special. This AGM point is something we actually miss out. We will always think ADDA means ordinary. So if I ask you if ADDA happens in EGM, that also sometimes will tell ordinary. It's not the case. That's why we should read the Bare Act. It says all points in AGM is special except the 4. But in special business, in EGM, in any other meeting, everything is special. That includes ADDA. So if any of these ADDA points, directors happen in the extra, one director dies, immediately a new director I'll appoint, it's a special business. How do I appoint him? That is the resolution. Resolution is how I appoint that person, what majority I do, what is the procedure. So that is why business and resolution are not linked at all. Are not linked at all. Removal of auditor, ordinary business or special business? Removal of auditor, I don't care where it happens. Special, because what is ordinary business? Only appointment of auditor. Correct. So appointment and remuneration is only ordinary. So if I say removal of auditor, whether it happens in AGM or EGM, it is always special. Correct. What about removal of director? You see the list. Removal of director. Special, that's all. Special business. Removal of director, special business. Whether it happens in AGM or EGM, no problem. Now for removal of director, what resolution is needed? Removal of director, which you only read, 169. Are you getting it? Don't get. What business it is the first question. What resolution is the second question. Right? Is it linked in any way? No. Special business, ordinary resolution. So removal of director at AGM, special business, ordinary resolution. Removal of director at AGM, special business, ordinary resolution. Some things are ordinary business, ordinary resolution. For example, appointment of auditor at AGM, ordinary business, ordinary resolution. Ordinary business, ordinary resolution. Removal of auditor, correct. Removal of auditor at AGM, EGM, I don't care. Special business, resolution. Special resolution needed at that time. For auditors, it is special. 140. We have seen, no? 140. Correct. So appointment of auditor, if it is at AGM, it is ordinary business, ordinary resolution. Appointment of auditor, if it happens in EGM, for example, it is a special business and ordinary resolution. Appointment of director at AGM, ordinary business, ordinary resolution. Appointment of director at EGM, special business, ordinary resolution. Removal of auditor at AGM or EGM for that matter, special business, special resolution. Removal of director at AGM or EGM, doesn't matter. Special business, ordinary resolution. So it's all different. It is not linked in any way. Now the best part, what notice is needed? Right? Is it ordinary? Is it special? What notice? So these are the questions that they can play around in the exam, and these resolutions are there forever. And in the act, if nothing is given, what should I assume? Ordinary or special? That's what, correct, you're right, ordinary. How did you tell ordinary? If nothing is given in the act, is it ordinary or special? How did you tell ordinary? Yeah. So actually you are using an interpretation of statute without knowing. Right? Correct. We'll see that. So if nothing is given, it obviously should be assumed ordinary, because if it was special, they would have given special. Go like this here, special. If special is not given, then it is ordinary. But if ordinary is given, anyway it's ordinary. So many times in law they have simply said by a resolution. So when nothing is given, what should we assume? Ordinary resolution. Correct. So if you see, that is, these are some of the interpretation points. Now we'll have to come to the, we have just told what type of resolution, ordinary or special, but we have never discussed what do you mean by ordinary resolution and what do you mean by what is a procedure. So next part, this is very simple. Any doubt? This is done. Any doubts here? Business is done. After business, so this both are done. After business, we need to put our concentration here. Ordinary resolution, special resolution. So resolutions. My handwriting is so amazing. 2 minutes later, I only don't understand. Yes. The reason why I cleared CA in first attempt is because of my handwriting. The evaluator didn't understand my handwriting. He thought if he had failed me, I will again come back next time to him only. So he said, okay, pass. Simple, very simple, correct. So resolution, if those people who feel that you need amazing handwriting to clear the exam, I am provided that exception, correct? So yes, resolution, ordinary, then special. Ordinary resolution is given in section 114. Section number ignore, doesn't matter. I told you for 2 days you will be like, what all sections is telling? You ignore. Concept, if you understand, more than enough. Let's read 114 and 1142. That's why I told, if you have the app, no, whenever you want, you can aram se see. If you have the book also, whenever you want, you can see. It's up to you. Anyway, I'll put everything on the screen. But for you to see at home and all that, okay, this is very simple. You only read, then we'll discuss together. Now is the time slowly when you can only start reading. 114. This is all CA inter syllabus, but very much relevant for our exam, for CA final. Very much. Online, please read, guys. Yes, it's on the screen, so no need to open anything else. You can read on the screen itself. A resolution shall be ordinary resolution if the notice required under this act has been duly given and is required to be passed by the votes cast, whether on show of hands or electronically, as the case may be, in favor of the resolution. You can ignore this point actually, leave it later. Ignore that. Whatever I have marked, you can ignore. A resolution shall be ordinary resolution if the notice required in this act has been duly given and is required to be passed by votes cast in favor of the resolution exceed the votes cast against the resolution. That's all. Means what? Simple majority. When I say simple majority, is it more than half or more than 51%? More than half. Votes cast in favor must be more than votes cast against. So very, very simple. So in the exam, all they see is votes. First they say notice should be given validly. We haven't even discussed the notice. Notice should be given validly. Notice has to be given validly, I know. We will see that notice part. Then votes cast in favor will be more than votes cast against. That's all. Votes cast in favor must be more than against, which simply means in normal English more than half. That's it. More than half. For example, now tell me, if there are, let's say, 1,200 people in the company, 1,000 equity shareholders, 200 preference shareholders. Ordinary resolution will be passed at 601 or 501. Why? Preference shareholders don't have voting rights. So is it 501 or 601? What if they vote also? Can they vote? Certain situations they cannot. Otherwise, one second. For the example here, voting power. Will they have voting rights or not is the question. Correct. Right. So if you see, the share capital of a company is only two types. One is equity share capital with voting rights or with differential voting rights, whatever, or preference share capital. Generally, for preference share capital, what is the scene? If generally voting rights will be only if you have equity shares. For preference shares, obviously you will not get any voting rights. That is clearly given in section 47. Every member of a company limited by shares and holding equity share capital shall have a right to vote. Every member of the company limited by shares and holding equity share capital shall have a right to vote. So if you are holding preference shares capital, will you get voting rights? No. So 43 and 47 combined reading, we have seen that preference shareholders do not have voting rights. But there are certain exceptions, as he said. If the cumulative preference dividend is not paid for more than 2 years, then automatically preference shareholder also will get voting right. Otherwise, no. So very simple. Combined reading of section 43 and 47. Combined reading of 43 and 47 will tell me the answer. It is 501. Now, of this 1,000 equity shareholders, okay, 800 come for the meeting. 200 people bunk, aram se, mass bunk. So what? Is it 501 or 401? Why? Why? Yes, votes cast in favor. Votes cast. And these 200 fellows are not even coming. How can they vote? Sorry? Online. Online also, when I say bunk, I meant they don't vote only. They don't participate. Take it that way. They don't participate. They neither do they come for the meeting, nor do they participate in any voting. So this is obviously 401 because of the word which says, cast, votes cast. Votes cast means you have to vote. If you don't vote only by not coming or by not voting, then no, it will not be counted. Lastly, of the 800 people who come, 600 cast the vote. 200 come for the meeting, mind you. 200 come for the meeting only for eating. Catering would be nice. They'll eat and they'll go. They'll have some 2-3 shares. Properly they'll belt worth 1,000 rupees worth food and then leave. 600 they come and they also vote. Now tell me, 401 or 301? Mind you, they came for the meeting. Just that they didn't vote. Or you can say they abstained from voting. 301, 401? 301. Why? Cast. But if you read this, all that we discussed is finished off in one line. These two. So entitled and voting. Entitled means those who have the right to vote. That is only equity shareholder. For section 43 plus section 47. And voting. Even if you have the right to vote, boss, you should come and actually cast your vote. So as an examiner, what is the keyword that he will look at? Only 3 things. Notice, votes cast in favor must be more than votes cast against. Third one, entitled and voting. That's all he will see. If you underline those 3 whatever phrases that I told you, full marks. Should I write exactly the way that is given in the Bear Act? Impossible. I can write law in my own words but using the keywords, but not write my own law. More than 51% voting power is needed. Simply write. Correct? So it's all about keywords. They will not care about anything. Votes cast in favor must be more than votes cast against. Can I write more than half of the vote, more than 50%? Yes, I'm just saying, worst case scenario. If you don't know votes cast in favor must be votes cast against, you can say more than 50% of the valid votes. Enough, correct only, no? But what is the keywords? Entitled and voting. Who will be entitled? Equity shares. And voting means those who abstain must be excluded. Those who abstain must be excluded. So if abstain means those who don't want to vote, that should be excluded. So basically third point, so first is this notice point, then cast in favor against, third point is entitled and voting, that's it. Entitled and voting. Entitled means what? Equity shareholders. And voting means what? Those who actually cast the vote. Notice, votes cast in favor must be more than against, entitled and voting. If this is ordinary resolution, what is special resolution then? 2/3, 2/3, half, 1/3. More than 2 times. Means if 1 is against, 2 should be for. So 2/3. If there are 3 votes, 1 is against, 2 is for, means 2/3 only, no? Is it 2/3? Read 1142. That is the mistake that we do generally. this. Yes, preference shareholders can vote in matters that affect their interest. Yes, all that correct. Here, what do you think? How much? 2/3? 75. Is 75% clearly given there? No. Correct. You can write 75, no problem. That's what I'm saying. You can write law in your own words, no problem. Correct wordings only need not be written. Absolutely fine. We only see 75%. We'll miss out point number A, point number B. Those are also very important. What is point number A? Point number B, notice should be clearly given. Notice is always given under section 101. We saw that the other time. To understand who will give notice. Act was silent. So what did we say? Board. So first of all, notice must be given validly. Second, if you see here, the intention to propose the resolution as a special resolution has been duly specified in the notice calling the general meeting. Intention to propose the resolution as a special resolution shall be given. Means in the notice, there has to be a mention that the intended resolution is a special resolution. In the notice, you have to mention that the intended resolution is a special resolution. In the notice, you have to mention that the intended resolution is a special resolution. Means what? When you are sending the notice, you should clearly tell that the proposed resolution is a special resolution. If you miss that point, and let's say shareholders pass 100% majority, is that resolution valid? You miss out that point in the notice, but still shareholders go ahead and say 100% they agree, 100% resolution they have passed. Is it still valid? No, not valid, because this particular section clearly gives 3 points. Intention, notice, then the votes. And if you see semicolon and, which means everything has to be followed. If the procedure is not followed properly, then gone. Let us say 99.99% say yes. One shareholder says no. Can the shareholder go to the court and strike this down, get this struck down? Yes. Why? Because in the notice it was not mentioned it was special resolution. So it's not about the decision. Even if you take a revote, he will lose the case. It's okay. But for his intention is, procedure is not followed. So all this procedure will be followed by the company secretary, or they'll come to a chartered accountant to ask what all to be done. So if you see, that's the thing. Votes cast in favor, whether by on show of hands, whatever, shall not be less than 3 times the votes cast against. So if one vote is against, minimum 3 must be for. Means out of the 4 votes, 3 out of 4 must be for. Means what percentage? 75. Now my next question is, greater than 75 or greater than or equal to 75? See, all this they'll ask in the exam. Greater than or equal to or greater than? Why? Not less than 3/4. But if you see ordinary resolution, greater than or equal to 50 or greater than 50? Greater than. Are you getting it? Small differences. It is greater than 50 there. Here it is greater than or equal to 3/4. It says not less than, which means greater than or equal to 75%. Same entitled and voting. That is obvious. It will not change. right? So notice, in the notice mention that the intended resolution is a special resolution, then 75%. Of what? Those who are entitled and voting. This is how we need to figure it out. Special resolution is this. In the exam, if they, in the Bare Act, if they have given nothing, then it is what? Ordinary resolution. So if Act is silent, it is always ordinary resolution. Tell me. Special resolution is always, resolution is done by what? By shareholders or board? So what are you saying about board, matters relating to board? No. Why? Those are only 4 businesses that we discussed. There are so many businesses, no? No, because there are so many items. Each and every section has different things. So you cannot say that. So for example, if I want to alter the MOA, will you look it as the board, or will you look at the auditors? That's more related to the day-to-day operations, no? MOA, AOA. But if you see what resolution is needed, special resolution is needed. So you cannot categorize like that, summarize as like that also. Each one is different, right? So ordinary and special. Is there something called where 100% resolution is needed? 100%. What is it? Like everybody should agree. Everybody should agree. Can that also be a part of this resolution? Can that also be a criteria? Yes. That we will see later. There is one more that is called unanimous, which we will say later. Unanimous means what? Everybody should agree. There are minor differences there, that's why we'll see later. So here, uni is single, animus is mind or heart. Uni is single, animus is mind or heart. Means what? Yes, it's as if everyone, basically those are 100 people, it's as if one person only is telling. Single mind, single heart, unanimous, animus. So that's the thing. So if you see, if a person who is very generous, you generally say he's a very large hearted person. Does it mean his heart size is large? No. Correct? So another way, people who really have very strong vocabulary use this word. I don't know if you have heard or not. They have used the word magnanimous. Again, animus is heart. Magnum ice cream you have had. It's Chocobar double XL, no? Correct? So magna means large. Magnifying glass. These are all Latin terms. So in predominantly English is one copy-paste language only. From all other languages they have copied. They have copied from Sanskrit, copied from Latin, Greek, all those things. That's why English sometimes is Greek and Latin. Don't understand. Like Shashi Tharoor, if you start speaking, don't understand. So if you see, magnanimous. Magna means large. Animus again is mind. So magnanimous person is a person who is very generous. There you can't say mind, large mind and all. It depends. Sometimes it's mind, sometimes it's heart. That's how it is. Magnanimous. Like if you follow cricket, if you have seen the attitude of Mahendra Singh Dhoni, if there are 3 balls and 16 runs needed, his face will be the same. If it is 16 balls, 3 runs needed, face will be the same. His expressions will be the same. What he goes through, there may be many things that is going through, but to the outer world, his mind and his heart is always equal. Correct? You don't see any variation. Compare that with Virat Kohli. I'm just saying, he is very animated. You can't say Virat Kohli is bad or Dhoni is bad. Each person has a different characteristic. This fellow, at the shortest of the things, very animated character. Always he puts his heart up his sleeve. So you cannot call Virat Kohli being equal at all times. Rahul Dravid, on the other hand, was always like that, where you won't know what he is trying to think. Correct? So if you see, that is called equanimous again. See, again it's all derived. One word, if you understand, no, everything is simple. Equanimous. Equanimous is a person like Mahendra Singh Dhoni, who any point of time, always his mind and heart, he won't even know what is happening. No reaction. On the other hand, definitely you cannot call Virat Kohli equanimous. He is an animated character. Right? Always he is very reactive. Very reactive. That's how it is. So you can see emotions in him. But in Dhoni you cannot see any emotion. That's the thing. So you can't say one person is bad or good. It's the characteristic trait of each person. So that's how it is. So unanimous is as if a single mind, single body, single heart. So uni is single, unilateral, you would have heard, no? Unilateral, single side. So that's how it is. So if you break it down, you'll understand these things. So this is about the resolution. So there are certain unanimous resolutions, also special, ordinary, like that. As I told you, special resolution, they'll clearly give that the resolution should be special. So example would be removal of auditor. I already told you 140. Absolutely clear there. They have specified, you cannot think of any other thing. Special resolution. By a special resolution. Example. Then if you see, for example, alteration of articles, alteration of memorandum, for example. Company may by special resolution alter the memorandum. If nothing is given, then what should I do? I told you ordinary. 90% of the law, nothing is given actually. For example, we have already seen, we'll just see what all we have seen already. This 152.2 we saw. Every director shall be appointed by company in general meeting. How? Ordinary or special? Ordinary resolution. Correct? Ordinary resolution. Then I'm taking examples from whatever you saw. Pillars of corporate democracy. One is what? Appointment of director. Appointment of auditor also you see. Appointment of auditor. Every company shall at the first annual general meeting appoint an individual. What resolution? Nothing is given. So what should you do? Ordinary. Generally the word ordinary is not mentioned in the law itself. It is either special or it is silent. If it is silent, ordinary. But there are certain peculiar sections where they have actually mentioned ordinary resolution. And one such example is again pillar of corporate democracy, removal of director. Very, very peculiar. They generally don't do this. They generally don't do this. But in this particular section, they have mentioned the resolution to be ordinary resolution. So this is a peculiarity. General rule, special is given means special. Nothing is given means ordinary. But there are certain amazing sections where they have actually given ordinary. This proves that the law doesn't want any confusion. Because if I say resolution, you can play around, you can insert in the articles, no, simply. That resolution means special, simply. And then it may lead to litigation and all that. But there are certain things law doesn't want any confusion. And what are those points? This only. In removal of director, you can't ask for special resolution. And I will not confuse you also by simply giving the word resolution. That's what the law says. Lawmaker says there is only one way to throw out, and that is ordinary. I am not giving extra protection for the director by asking them to do special. No. So these are when law is crystal clear about it that they don't want to change. Then what resolution is needed? When they'll give ordinary resolution. One more logically I'll tell you. Let's say you have named your company stupidly Infosys. You have created a Google platform search engine and you have named your company Infosys. So there will be like one sister popping up there who will give you all the information, just telling. And isn't this similar to some other company? We know Infosys. Such companies will never be registered if it is similar sounding to some other company. But let us say, for argument's sake, for theoretical purposes, they have registered this company already. MCA, our ROC has registered by mistake. Infosys comes to know about it. Automatically, they ask them to change the name. Name clause is obviously given in the MOA. If you are demanding me to change the name, I have to alter the MOA. I just showed you the section. Alteration of MOA, what resolution? A special resolution. So now tell me, government is ordering you, Infosys, to change the name. Now you logically, they are ordering you. They are ordering you because you have infringed a trademark already and you are creating confusion. They are ordering you to change. Now tell me logically, you are obviously amending the MOA. Now tell me logically, do you need to pass special resolution or it is just an administrative process? You have to pass some ordinary resolution just for the heck of it. It's an administrative procedure. Do you have a choice? No choice. You have to do it. So if you see, now in this scenario, will I go to section 13 and follow alteration of memorandum provision, special resolution? No. That's why you see, I'm just giving you an example. This is one more example, section 16. All this is CA inter. Sir, inter and all, it was there, sir. Yes, sir, it was there. So if you see this. Section 16, a separate section is there. Rectification of name of the company. If through inadvertence means accident or otherwise means not accident, you purposely did it. A company on its first registration or registration by a new name in the opinion of central government is identical with or an application by a registered proprietor of a trademark, Infosys, then they can ask you to change the name. They will issue a direction to change the name. And you need to do what? And you need to do what? They have never said here, pass a resolution. What have they told? Adopt an ordinary resolution. Means you have no choice. These are some of the areas where law has given the wordings ordinary resolution. Otherwise, they'll never give. Section 16 and section 169 are two examples where law has given the word ordinary. Logic is different. 169, they didn't want to create any confusion. They didn't want to give extra protection to whom? Director. But 16, what is the logic? Administrative procedure. There they have used the word pass a resolution. Here they have used the word adopting. Are you seeing the difference? Adopting means you have no choice. So I'm demanding. Sir, can I pass an ordinary resolution against it? No. You have to pass. I'm ordering you. So just for you to take it on record, you adopt that order by passing an ordinary resolution. Sir, but section 13 says special resolution. I don't care. Now you are only, I'm a client in front of you. I've passed CA inter. I'll tell you, sir, as per 13 it's special resolution. As per 16 it is ordinary resolution. What will you follow? When the government has ordered 16 or 13? Why? See, again, these are all interpretation of statutes. The specific section will override the general section. These are all rules of interpretation. which actually 90% of it comes by pure common sense. It comes by pure common sense actually. Which one? No, it will be adopting an organization. One normal deemed meeting will happen. They'll send for voting. There will no specific meeting conducted. They'll send for online voting. They'll explain it in that this has happened. So please vote for it. No, in that you clearly have to mention that you have to say yes to this because it's an order given by the government. Order is hereby attached. But since I am just taking your approval, I want to keep it on board for documentation. So please say yes. That's what it is. If you say no and everyone want to do ulta only and they put no, then you have to call one more thing because tomorrow you have to send that documentation to the government saying that we have adopted the ordinary resolution. Again, it's the company secretary's duty to tell you have no option but to say yes. You have no option but to say yes. Online people, good morning. I think they slept off. Yes. So that is it, guys. These are the two things. So tomorrow we have to do the other things. That is my notice, and then of course do the other basics, and then we can start off the entire thing. The basics are a lot. Basics are a lot. The types of companies, all that. So tomorrow we'll do one more round of basics, and because these basics are what these are not basics. These are actually foundation for the future classes. Tomorrow I will not explain what is special resolution. I'll just say special resolution, you will understand. What is special resolution? Three things. First two things we'll forget. One, notice should be sent. Second, in the notice you have to mention that the intended resolution is special. If the second one is missing, gone. One fellow also told no, can strike down the entire, can go to the court and strike down. Courts will never interfere why you said yes, why you said no. Never. But courts will interfere on one thing, Cyrus Mistry. Procedure is not followed. So they will only interfere when procedure is known. They will not say why you removed Cyrus Mistry. No, the way you removed him was wrong. Nobody will say why you removed him. So which one? Mistry is demanding money, no? He is telling boss, you didn't throw me out properly. Give me now compensation, crores. So take my shares. I have some 18% stake. Take it. 100,000 crores he has quoted. Ratan Tata said, are you a fool? That is the fight that is happening. Mistry is telling the way you removed me was wrong. Now I demand compensation. Give me 100 crores. Sorry? He said, I don't want to continue. He only resigned. He said, I don't want to continue in your bloody company. I'm resigning. Sorry? Sorry? Correct. So the thing is, you have to, I thought you were talking in English, then I have to, got it, correct. So yes, so you need to, obviously, the way you remove should be as per the procedure. He said, I don't want, he already resigned, he will not continue also. But the way you removed me was wrong, so pay me compensation. Like for example, if an employee is thrown out without following labor legislations, do you think he'll come back? He'll say, boss, the way you removed me is wrong, so pay me, 100 crores you pay me now. It's all about compensation. And it's the fact that in the eyes of law, you are right. Other person is wrong. In the eyes of law, I am right. What I did was right. That is the case that is still going on. Right? No, then you already removed improperly. No, for that you have to demand compensation. Remove the properly is the second part. But first, why did you remove me in an improper way without following the procedure? So it's always like that. Law works like that. Great. On that note, we shall continue tomorrow, guys. See you. Bye. Tomorrow we'll finish off all the other important basics. So the foundation will be very strong. Then we can go ahead. Yeah. Okay. See you. Bye, online friends. Take care.